All right. We are back. It is June 18th, 2020. The Economic Justice Law Review Weekly Scholarship Digest. I'm your host, Andre Smith, Dre Smith, Smitty Blondon. You know me, 14 years, 15 years law professor at Florida International University, College of Law, Penn State, Howard University, Widener, Delaware. And for those that know me, my main subject area was tax, also administrative law, some sports and entertainment law, but it all wrapped up into basically economic justice. So what we do here at the Economic Justice Law Review is we don't publish new scholarship or original scholarship. What we are is the repository for scholarship relating to race, economics, and law that's published in the journals all around the country. Also books too, but this week we have some exciting law review articles. And again, they don't necessarily have to say race and economics. It is my belief, very strong belief, that almost every every racially subordinating or racially debilitating circumstance can be described in terms of in economic phraseology. More specifically, we can describe it as the denigration of an otherwise or an idyllic free market. So if you're battling with neoliberalism, most folks have external or exogenous critiques of neoliberalism. However, there is a lot of room, and I hope we take it up, for the internal or endogenous critiques of so-called free market fundamentalism. And what I mean by that is this free market that's supposed to solve racism and be free and meritocratic for everybody assumes four things. There has to be four things present for this market to exist and operate in the way folks claim it does. And number one, that everyone is a profit maximizer. Everybody has perfect information about everything. That there is Everyone is able to enter any market they choose or leave any market they choose, which is called perfect competition, and that there are no transaction costs. There's no externalities. There's nothing. There's no crime or taxes or anything in this idyllic world, right? So it doesn't comport to reality. Moreover, we know that not only in this world are there asymmetries with respect to capital or the ability to enter markets, where there are asymmetries with respect to information. There are asymmetries with respect to the distribution of transaction costs like taxes and whatnot. We know that that these asymmetries are racially asymmetric, right? That black people are disproportionately subject to society's externalities and transaction costs. That black people, information about and available to black people is racially asymmetric with respect to the market. That capital gaps, in terms of not just financial but human, social, and political capital gaps, represent racially asymmetric market competition, and that between blacks and white folks, the capacity, the dynamic of withdrawal or exclusion from the marketplace. In other words, exclusion or discouragement from society at large, or the withdrawal from the marketplace by blacks ourselves because it doesn't serve us, also reflects asymmetrical profit maximization, which I call asymmetrical market engagement. So those are the four categories that we place all scholarship within to show that it not only reflects our subordination today, but that a market that is denigrated by racism in these ways will perpetuate and exacerbate the racial wealth gap long into the future. So I guess I could put it this way. Let's say that reparations came tomorrow. Like, I'm going to do a Derek Bell thing with the what ifs, right? A hypothetical. So let's say reparations, 14 trillion. Bob Johnson just spoke on $14 trillion in reparations. If all that were to come today, now I don't mean to invoke the old David Chappelle skit, which really caricaturizes it, but the fact remains is if the market stays asymmetric with respect to information, remain asymmetric with respect to the distribution of transaction costs and externalities, if that financial capital also left open the human, social, and political capital gaps, then we would see that $14 trillion leak right back on over to the other side eventually. Not as fast, again, as the David Chappelle skit, but you get the point. So, in service of all that, every week we are presenting 3 pieces of scholarship, what be they law review articles or published books that we're going to characterize in terms of their degradation or denigration of this idyllic free market or this fundamental or free market fundamentalism. Paper number 1, or a law review article number 1, we got Camille Gear-Rich out of USC on race and assisted reproductive technology. Right? Medical, racialized medicine, and all that in the law. Again, following upon Dana Matthew Bowen, Michelle Goodwin. Different issues, but definitely a welcome addition. Camille Gear-Rich, contracting our way to inequality, race, reproductive freedom, and the quest for the perfect child. That's been published in the 104th volume of the Minnesota Law Review, page 2375 this year. The next 2 papers are very similar in first, they're both out of the Virginia Law Review, and they're both dealing with, I'm going to borrow Ruha Benjamin's term, race after technology, or the new Jim Code. Fantastic book, and now a lot of law review articles are explaining the legal ramifications of what she discussed in her book, and other people discussed in their books, about the way in which computer algorithms, artificial intelligence, data mining, and all that will perpetuate racism in the future if we don't watch out. It can be tools to correct racial micro corrections. However, if we're not aware of the racial microaggressions, then we can allow it to, again, further denigrate the what we would hope to be a free and fair market, and make it that much more racialized. So, 2 papers on top of Camille Gear-Rich's is Pauline Kim out of Washington, St. Louis, on racism and artificial intelligence as racially asymmetric market information, racially asymmetric market competition. It's called Manipulating Opportunity. It's in the 106th volume of Virginia Law Review, page 867. And in the same issue is Hellman on determining, and she's Professor Deborah Hellman out of UVA, on determining when discrimination is wrong. And it's Deborah Hellman, Measuring Algorithmic Fairness, 106th volume of Virginia Law Review, 811. And I just spoke about Dana Matthew Bowen, so shout out to Dana, who was previously at UVA and is now the dean at George Washington Law School. Also, shout out to Kim Ford Mazrui over there at UVA. So, Camille Gear-Rich, Pauline Kim, and Deborah Hellman are 3 features in this week's digest. All right. Just reminding you, last week we talked about Britton Purdy out of Columbia, along with, it was a group project, something like the Symphony or Wu-Tang. Jedediah Britton Purdy out of Columbia, David Singh Grewal, Berkeley, Amy Kapczynski, Yale, K. Sabil Rahmana in Brooklyn, building a law and political economy framework beyond the 20th century synthesis. The 20th century synthesis. I agree with their point here. I think it can be made a little differently, but when talking about the 20th century synthesis, they're talking about this pincered attack on race and rights by privileging law and economics in one context, but then being anti-realist and not considering consequences at all when it deals to racial issues and questions of equity. So, when is law and economics appropriate, right? If at all. All right, so that was a great paper by them. Kuda Kalua on caste and food discrimination last week, which of course relates very well to Isabel Wilkerson's new book coming out on the caste. And then Lamar Campbell out of Nova on transitional justice, social school segregation, and the myth of black intellectual inferiority. Right, Camille Lamar Campbell, very good paper on transitional justice, which might have been less relevant before this current uprising, because before this you might have think, well, it's the status quo. Why would we do extraordinary? Why would we take extraordinary actions towards justice? However, this current climate definitely is suggesting even stronger that we are a more as she calls it, a transitional justice regime is more appropriate. For that, we've done Venice Berry on racialism in the media, Andre Perry on the evaluation of black-owned real estate. We can go on and on and on. As a matter of fact, Kohler Hausman, we're going to invoke some of these in the papers that we're talking about today. So first one featured this week, Camille Rich's Contracting Our Way to Inequality, Race, Reproductive Freedom, and the Quest for the Perfect Child. All right, so I describe it as such. First of all, what it's about is a contract dispute, right? I believe a contract dispute over mistakenly implanted gametes of a black donor towards a white lesbian couple that insisted, or at least were pre-screened to expressly want a same race or white child. Okay, so racism in assisted reproductive technology, or ART, reflects racially asymmetric market imperfections more than they exacerbate them, right? Greater reproductive choice reflects the racial wealth gap. White people have relatively greater, and black people, of course, then relatively lesser capacity or capital to enter ART markets, thus racially asymmetric market competition. Now, to the extent the desire to have a same-race child reflects the myth of black inferiority, those decisions would also reflect racially asymmetric market imperfections in terms of untruthful and perpetuating untruthful information about black people, or what we all know as stereotypes. The seemingly race-neutral excuse that a same-race child forecloses questions of family integrity, it may seem race-neutral, but I think that also refers to the maintenance of social capital. And we know that there are racial social capital gaps, right? So to maintain white social integrity as far as white institutions and friendships and relationships, yeah, that has a racially economic effect. Even if minimal or small, it is there. And if we're talking about microaggressions, I don't think the answer or query that it's too small is relevant when we said in the beginning it's micro, right? A piece from the paper. Although Cramblett requested and purchased sperm from donor 380, a blonde, blue-eyed white male, the clerk handling the transaction misheard her request and sent her sperm from donor 330, a brown-haired, brown-eyed black male. The clerk's mistake erupted into a commercial controversy, a family controversy, and a racial controversy all in one. Cramblett, as a member of a monoracial blonde white lesbian couple, had contracted for the chance to form a white nuclear family. While she ultimately opted to give birth to the mixed-race baby, now actively growing in her womb, Cramblett also filed suit for the clerk's racial mistake, as she effectively had been denied the benefit of the bargain she contracted for in her ART transaction. Wow. So we got a tort or contract claim about not getting what you thought you were going to get in a commercial contract, right? Specifically, both contract and tort law seem amenable to providing Cramblett relief, but for the hanging question of whether public policy considerations prevent recovery on a contract for the sale of a racial product. Right? Interesting stuff. Now, on the one hand, it could be further complicated by the claim that that there was no racial bias involved, that there was no racial animosity involved. But I think we should be past. If we're talking about things economically, we're past animosity. We're full on into disparate impact, whether it be by the government or in a private setting. So this is very interesting to me, even in the context of it being very clear that some people do want same-race children. That racial commodification, as Gear Rich, should it be respected on the one hand and enforced, or can the court basically say, that's an agreement you guys can come up with, and if you guys agree to it, that's fine, but I would not sully the government with enforcing it. That's kind of basically going back to Shelley versus Kramer. those agreements are still out there, right? The racially restrictive covenants. And if people read them and choose to honor them, that's still, I know it's controversial, but I've heard arguments about this since I was a first year in law school. That's still an agreement. Now, the question of whether it's binding by law and whether that determines it's a contract, okay, so what? Right? So what? That these agreements still exist is one thing. The question becomes whether they are formalized in terms of a contract term that is respected and then enforced by the law. Very interesting paper by Camille Rich at USC. The second paper, and again, this is the first of two papers published in the Virginia Law Review dealing with artificial intelligence. So this is Pauline Kim, Manipulating Opportunity, 106 Virginia Law Review, 867, 2020. She deals with Title VII and the maldistribution of job postings based on racialized computer algorithms, described in this context as online personalization. So basically what we're saying is, we've talked about AI in criminal law enforcement, insurance context, and how they can exacerbate transaction costs, how they can be used, how it might be used in affirmative action, all types of different ways. Here is a specific context, not the employer themselves, but let's say hiring agencies, recruiters that use AI to target individuals, but those computer programs distribute the online postings to who they think is qualified in interest, which the algorithm may disproportionately identify as white and disproportionately not identify as black or brown. So again, we know that when you're on social media, there are ads that are targeted to you. However, to the extent you are targeted because you're black with music and entertainment versus targeted with job opportunities for a similar situated white person, that will exacerbate racial wealth gap. That will reduce opportunity. So that is her discussion. By petrifying racial bias, or my description of it in economic terms is, by petrifying racial biases in commercial decision making, artificial intelligence reproduces racially asymmetric market information in terms of untruthful information about black people. In other words, it perpetuates the myth of black inferiority, which ultimately exacerbates racially asymmetric market competition when it's used to exclude black people from gainful employment, i.e. the unequal distribution of opportunities, as Pauline describes it. That's straight from her paper, the unequal distribution of opportunities, which again, if you think about it, was the linchpin or the basis of the claim against affirmative action, right? That it's reverse racism because of its the racial distribution of opportunities, right? Okay, so again, this is in line with a lot of papers that are dealing with artificial intelligence that's been hot in 220. Again, I call the mother of all of them the book Ruha Benjamin's The New Jim Code, Race After Technology. She is a professor out of Princeton, but also again, out of entertainment. There's a reggae singer named Etana, E-T-A-N-A. Go to YouTube and check out a song of hers called Wrong Address, right, where she's discriminated against in Jamaica, and in regards to whether the perpetrators are black or white, they are identifying and excluding her based on her address. And yes, it is race neutral. However, the racial impact of it is absolutely clear. See also Jason Bent. I'm going to talk about his. Matter of fact, I'm going to save him for later. But Jason Bent out of Stetson had a great paper called Algorithmic Affirmative Action. Is algorithmic affirmative action legal? And I think it's more appropriate for me to talk about that in context of the next paper we're going to talk about. But while we're talking about Pauline Kim's, let's hear from her specifically. When predictive algorithms are used to allocate information about opportunities like employment, housing, and credit, they can reproduce past patterns of discrimination and exclusion in these markets. Again, right, who is it when they're advertising these lower rates because the Fed has dropped the rates down to zero? Impact all over the place. This article explores these issues by focusing on the labor market, which is increasingly dominated by tech intermediaries. These platforms rely on predictive algorithms to distribute information about job openings, match job seekers with hiring firms, or recruit passive candidates. Because algorithms are built by analyzing data about past behavior, their predictions about who will make a good match for which jobs will likely reflect existing occupational segregation and inequality. When tech intermediaries cause discriminatory effects, they may be liable under Title VII, and Section 230 of the Communications Decency Act should not bar such actions. So, I'm very glad that Professor Kim is dealing with race after technology or artificial intelligence in a discrete context. Again, we talked about it in terms of insurance, in terms of law enforcement, in terms of hiring, in terms of affirmative action. So, code, STEM. If there's any lesson we're going to take out of this outside of economic justice, man, I wish I could decipher these things. I do not have the tech background to be able to decipher when and how these algorithms are racially subordinated. Now, there are folks out there that do it. I want to say someone just hit me to the Algorithmic Justice League, I think it's called. So I'm very glad for the research facilities that are out there, but more of our kids, more of our young people, and more of ourselves. I don't have an excuse. I need to learn more stuff. I need to learn coding and how these are in fact perpetuated, because the next paper we're going to talk about is not just about how it perpetuates racism, but how we're going to fix it, how race consciousness is the only way to counter these biased algorithms, right? So that's That's Deborah Hellman, Measuring Algorithmic Fairness. How do you figure these things out? Again, the 106th volume of Virginia Law Review, page 811, 2020. My economic description of it. Again, she's the author of 2008's When Discrimination is Wrong, which really relates to a paper we did a couple weeks ago by Issa Hausman. I want to say Issa Hausman, and she did a piece on the content of equality and equal protection. What do we mean by equal and equal protection, especially in the context of the affirmative action lawsuit against Harvard, where the purpose is to elevate the inclusion of African Americans or black people. At the same time, they are discriminating against high-performing Asian students, right? So what is the content of equality? What is our parity? What statistical parity, in-group, out-group parity? What are we looking for as a linchpin, as the content of equal protection that would allow affirmative action for black folks and yet not discriminate against Asian Americans who have their own, who are racialized as well in this country? Okay, so again, she is the author of When Discrimination is Wrong. She tackles recent concern over algorithmic racial biases. This book is a complement to Jason Bent's Is Algorithmic Affirmative Action Legal? Great paper out by a professor. Where's Jason Bent? Jason Bent is at Stetson, I believe. Right. It's a complement by calling for race-conscious evaluation and manipulation of artificial intelligence for the purpose of counteracting its tendency to reproduce racially asymmetric market imperfections in terms of reproducing asymmetrically distributed employment opportunities, perpetuating asymmetrical market information, which is untruthful information about black people, and the maldistribution of societal transaction costs and negative externalities when used in law enforcement. So she even invokes the Compass program dealing with bail, right? The Compass program that was instituted by, I guess it was ProPublica, set risk standards or risk classifications for criminal defendants, and disproportionately found black folks as risky versus white folks as not risky. And not only is it a racial injustice, it's also a harm to public safety to the extent you're over incarcerating black folks, which will also lead to crime because the people that left behind are now even more impoverished versus greater crime from the white side when you're letting out people that are risky. And the problem is that you're using the same standard when they are two different experiences. So isn't it better, and I'm just going to use this as a silly example, if Pepsi drives black people mad, but Tab drives white people mad, then then you don't just use Tab or Pepsi, right? You incorporate the desires, interests, outcomes relating to both. However, that type of race conscious decision making is thought to be against the Equal Protection Clause. And so again, that comes into this thing with this question of what do we mean by equal? What does it mean? Again, Idelson at Harvard, what does it mean to treat people as individuals if we know about the racialization of their environment and culture, right? Okay, so let's talk about this, go straight from the paper before we conclude. Compass, right, the program we were just talking about. Compass assigns each person a score that indicates the likelihood that the person will commit a crime in the future. In a high-profile expose, the website ProPublica claimed that Compass treated, I'm sorry, they weren't the authors of it, they were the critics. The website ProPublica claimed that Compass treated blacks and whites differently because black arrestees and inmates were far more likely to be erroneously classified as risky than were white arrestees and inmates, despite the fact that Compass did not explicitly use race in the algorithm. Remember, I was just talking about Itana's thing, wrong address? Okay, the essence of ProPublica's claim was this. In forecasting who would reoffend, the algorithm made mistakes with black and white defendants at roughly the same rate, but in very different ways. The formula was particularly likely to falsely flag black defendants as future criminals, wrongly labeling them this way at almost twice the rate as white defendants. White defendants, on the other hand, were mislabeled as low risk more often than black defendants. So to the extent they're wrong in either direction, public safety is going to suffer. So furthermore, from her paper, the easiest way to fix the problem would be to treat the two groups equally in both respects, right? But what does that mean? A high score and a low score should mean the same thing for both blacks and whites. The measure North Point emphasized, and law-abiding blacks and whites should be equally likely to be mischaracterized by the tool. The measure ProPublica emphasized. Unfortunately, this solution has proven impossible to achieve, especially if you use the same standards for both. In a series of influential papers, computer scientists demonstrated that in most circumstances it is simply not possible to equalize both measures. The reason it is impossible relates to the fact that the underlying rates of recidivism among blacks and whites differ. When the two groups at issue, whatever they are, have different rates of the trait predicted by the algorithm, it is impossible to achieve parity by the groups in both dimensions. That's a long way of saying the recidivism rates are different, but what causes the recidivism also may be different. And so to use the very same standard to predict recidivism will lead to false outcomes. Again, if you are aware, if you are conscious of the distinction, and you are conscious that Tab drives white folks crazy towards recidivism, but Pepsi drives black people towards recidivism, then you don't use one standard. You keep Tab away from white people while you keep Pepsi away from black people. But does that violate the Equal Protection Clause for the government to be race conscious? Again, the affirmative action doctrine suggests as much, but Professor Professor Hellman isn't so sure. Part 3 explores contexts in which the use of racial classification does not constitute disparate treatment on the basis of race, and extracts 2 principles from these examples. Using these principles, this part argues that the use of protected classifications within algorithms may well be permissible. So she's a little more optimistic than Jason Bent, and his paper is Algorithmic Affirmative Action Legal. So those are the 3 great papers that we're featuring this week in the digest. Camille Gear-Rich, Contracting Our Way to Inequality, Race, Reproductive Freedom, and the Quest for the Perfect Child, in the Minnesota Law Review, Pauline Kim, Manipulating Opportunity in the Virginia Law Review, and also in the Virginia Law Review this quarter is Deborah Hellman, Measuring Algorithmic Fairness. So those are our 3 papers. These are 3 articles or our pieces of scholarship for this week. We will return next week with another 3 pieces of scholarship. Again, I'm DreSmith, Smitty Bonton, Andre Smith. I will see you again representing for the Economic Justice Law Review next week.